You gotta be kidding me. I'm never gonna post that. I have no one to post that bond for me. Please, Your Honor, I have
Your
to
Honor,
go.
can we potentially get an earlier court date?
The 28th is the earliest I can do. That's 1 week from tomorrow.
Understood, Judge.
So I'm stuck
Thank
here.
you.
I'm stuck here.
All right, thank you. Have a good day.
Thank you, Judge.
All right, we are on the record in the matter of the city of Wyandotte versus the city of Wyandotte versus Jennifer Vitro, 232420 A and B. And counsel?
Good afternoon, Your Honor. Christopher Shemke, appearing on behalf of my client. It's time we consent to the matter being heard via Zoom. As to the arraignment, we waive formal reading. My client stands mute.
Thank you. May I have your name for the record, please?
Jennifer Vitro.
All right, the court will waive the formal reading, enter plea of not guilty for purposes of the arraignment. And we'll schedule this matter for pretrial on December 5th at 9:45 a.m. Or counsel, we could do next week. You're back next week unless you think one of the other attorneys can.
No, Judge, the sooner the better. My client doesn't have lodging at this time, so I would anticipate potentially her not getting out of custody. So I would ask for the soonest date.
All right, we'll do November 28th at 9:45. All right, counsel has a bond.
Your Honor, my client indicates that she is homeless and that she was residing in her vehicle, which has been taken into custody. She receives SSD, but was not getting paid for another week. Judge, I'd ask that she be put in a position that if not able to get bonded out, that she at least can start accruing credit for time served. Thank you, Judge.
All right, ma'am, what's the address in Chesterfield?
That's my old house, but I do have somewhere I think I can go.
Where's that?
It's a friend's house in Madison Heights. It's 1310 Madison Heights. Christian Church.
You don't need to put the address on the record or live stream. And ma'am, why don't you work?
I'm disabled.
What's the nature of your disability?
I have cancer.
Are you currently undergoing treatment, or has that been something that's in remission, or?
I forgot treatment.
I'm sorry?
I've given up treatment.
You gave up treatment?
I also have a degenerative bone disease. I just want to go home. I have a visit with my son on Wednesday, and I really don't want to miss that.
What's your, what is it, supervised visit?
Yes, ma'am.
Out of which court?
Macomb.
Why is it supervised?
Oh, that's an awful long story. I lost my father in July, and right after that, my mother and my sister came after my son. My sister is a little not right in the head. They alleged abuse, which never in a million years. My son's my world.
How old's your son?
He's 7. He's almost 8. He's the most beautiful thing on the face of the planet. He's got eyes that light up your entire world. I'll tell you what.
Okay, And so, ma'am, what would be in your system if you were tested today?
I'm so sorry.
What would be detected in your system if you were tested today?
Marijuana.
Do you have a valid prescription for marijuana?
I know I was not, I didn't know I needed it. I just bought it. I get it for my nausea from the treatment.
Nothing else would be detected in your system?
I don't think so.
No heroin?
No, absolutely not. I do not mess around with that stuff. Absolutely not.
All right, given that you don't have any ties to the area, you don't have any stable housing,
My
the court's
boyfriend is down the
going
street.
to order a $5,000 10% bond. In the event you post bond, you're not to be released on GPS tether to the Wayne County Jail. You're not to possess or consume any alcohol or drugs that are not prescribed.
Wait, I'm sorry, what? I don't understand.
$5,000 10% bond. So you need $500 to post so we can guarantee your appearance. And in the event you do post bond, you cannot be released unless you have a GPS tether so we know where to locate you since you don't have any stable housing.
I do have housing.
In the event you're released, you're not to use any alcohol or drugs unless prescribed. Thank you.
I have housing.
Thank you,
I
Chair.
have housing.
Ma'am, that's the order of the court. Thank you.
But I have a house to go to. It's right in my court paperwork.
Ma'am, we are done. Thank you. You even wrote in your information homeless, so we're all set. Thank you. So we just have one more in custody and then I can, yeah.
We'll step right up.
All right, we're on the record in the matter of the City of Wyandotte versus Kyle Bollier, 232422. And counsel, your appearance, please.
Good afternoon, Your Honor. Christopher Shemke appearing on behalf of my client. At this time, we consent to the matter being heard via Zoom. As to the arraignment, we waive formal reading. My client stands mute.
Thank you. And sir, your name for the record, please.
Bollier.
All right, and the court will waive the formal reading, enter plea of not guilty for purpose of the arraignment, and we will schedule this matter for pre-trial on November 28th at 10:30 a.m. And counsel, as to bond.
Your Honor, as to bond, my client indicates that he will appear at any and all future court dates. My understanding he's not on probation or parole. I do not believe he's a flight risk, so I would be respectfully requesting consideration for a personal bond. Thank you, Judge.
Sir, did you complete probation out of the 35th District Court?
Yes, I did.
And when were you released from probation?
I was released, I want to say, like at least a month ago, over a month ago. He released me early, a whole year early.
Okay, and so what happened with the matter out of Allen Park in 2022? Dangerous drugs, felony. What happened with that?
That was supposed to be dropped.
You work, sir?
I am in between jobs at the moment, but I'm starting a new job next week, yes.
How long have you been in between jobs?
About a week and about a month. About a month or so.
Where was the last place you were employed, sir?
Shaw's Plumbing.
What's that?
Shaw's Plumbing, they're out of E-course.
Okay, and how long did you work there?
I worked there for about a year.
And so where is it that you say you're starting work with next week?
I'm supposed to start working with it's a lawn service. I don't remember the name of it. It's through some buddies of mine. They work for Novi. It's a lawn service. They do a lot of lawn and care, like the landscaping stuff.
So you're starting a lawn service job right before the snow starts?
No, they do snow removal as well. That's it.
Sir, if you were to test today, what's in your system?
There would be possibly cocaine, maybe methamphetamine.
Anything else?
No. I've been off the heroin for a year.
You don't use any Suboxone to help you with that, or no?
No, I hate Suboxone. I don't like them. I think it's just a substitute for the problem.
Okay. Ever failed to appear in court before, sir?
No, well, I think so, but not intentionally. But I failed to show up in court once prior, but not intentionally. I have a pretty good track record of showing up when I'm needed.
Okay. And sir, are you out on bond in any other jurisdiction?
No.
All right, given your previous criminal history, sir, and to assist in your own sobriety, the court's going to order a $7,500 10% bond. In the event you post bond, sir, you are to not use any alcohol or drugs unless prescribed, and then we'll see you back on November 28th.
Okay, so I got my personal bond.
$7,500, 10%, sir.
So what is 10%? You gotta be kidding me. I'm never gonna post that. I have no one to post that bond for me. Please, Your Honor, I have
Your
to
Honor,
go.
can we potentially get an earlier court date?
The 28th is the earliest I can do this, 1 week from tomorrow.
Understood, Judge.
So I'm stuck
Thank
here.
you.
I'm stuck here.
All right, thank you. Have a good day.
Thank you, Judge.
And then we're still on the record in the matter of.
I'm Chucky. Chucky means sober.
What did you say?
I said chunky means sober. You know, I've gained a lot of weight and I'm in a better spot, you know, and everything in my life. So I'm ready to do it now.
And that's the first time I've ever heard chunky mean sober. I mean, I'm super sober if that's the case. So I just want to point that out to everybody.
I'm glad you've made that point, Mr. Faber.
Thank you, Judge.
All right, then let's go on the record in the matter of, we'll be calling the matter of Huntington House Apartments versus Natalie Wally, 2302104. And counsel?
Mark Lando on behalf of plaintiff.
Okay, and Ms. Walid, your name, please.
Natalie Walid.
Okay, and so counsel, has there been a resolution at all, or what's going on?
Unfortunately, no, Your Honor. The notes that I got from counsel who handled the hearing this morning suggested that it was a little further along than I think anticipated, and we were not able to resolve the matter.
Okay, so I'm showing that there was a conditional dismissal to enter, and so, and that conditional dismissal. So the conditional dismissal entered, correct, counsel?
Yes.
Okay. And so who filed this motion? Because I'm having a hard time here in this online file. It's finally able to get back in. But how are we back here today?
I requested Your Honor.
Miss Walid had, I'm looking at the ROA online, Your Honor, and Miss Walid had sent some correspondence that the court recorded as received on December 8th. I have not been privy to that correspondence.
Okay. And so, ma'am, there was a conditional dismissal entered. And so, and you had requested this hearing, and what was the purpose of that hearing, ma'am?
Your Honor, in the court dismissal, per the negotiations that I had with the previous Huntington House representative in the breakout room, the total that was going to be due, to my understanding, was what's listed in the dismissal of $2277 to be paid by December 29th. My understanding was that I made the payments that are listed out in the dismissal, and I assumed that I would be able to pay the December 2023 rent late. The previous representative did not explain to me the language that he used in the court order that said and all additional fees. I corresponded a couple of times, and there's been miscommunication between the representatives, the leasing house, and the owner, the representative legal people like Mr. Landau, Huntington House leasing office, and Huntington House owners. There's been multiple miscommunications. I asked the young lady this morning, if I paid all of my payments, which I have, Your Honor, and I've paid those early, if I paid those as agreed by December 29th, in 9 days, on December 30th, I would still owe December 2023's rent. Would Huntington House move to evict me because I would still have a balance outstanding? And the young lady this morning said yes, that they would. That was not explained to me when we were in the court. Neither was it explained to me the 2 times since our last court hearing that I sent emails to Mr. Borkin, the previous representative, and to the leasing agent of this apartment complex. I would never have agreed on November 17th to pay $3,900 in 1 month. I just cannot afford that. I would have asked the court on November 17th to make some sort of other arrangements. So that's what I asked for clarification, and nobody from Mr. Landau's representative, the leasing agent, or the owners has gotten back in touch with me. So I felt like I had to get in touch with the court and have an actual formal hearing, because Mr. Borkin said the conditional dismissal is the binding document.
Okay,
And
so
document.
hold on, please. Hold on. So I'm reading the document. Defendant shall pay the following to plaintiff pursuant to the terms in item 3. The amount was $2,277, and that's what was due through November 17th. Okay, it says that right on here. Defendant shall pay the above along with charges under the lease as follows: $500 by November 30th, $1,000 by December 15th, and any remaining balance by December 29th, along with all charges under the lease which accrue through that date. And so, ma'am, those charges are additional rent. So why, unless you negotiated having the rent paid late for December, I'm not sure why you thought that you wouldn't have to pay the rent on time.
No, you're not. Because they wouldn't be on time already by December 28th, Your Honor. The rent is due on December 1st.
Ma'am, this resolution was as to the arrearage amount that was still owing. That
Yes.
didn't address what you still, that didn't do anything regarding your current due. So you're telling this court that you wanted to have a hearing because you don't agree with this anymore, because you couldn't pay your December rent on time. Mr. Goldpaw, I'm gonna have you please join breakout room 2. Is that what you're telling the court, ma'am?
That I did not understand that I would not be able to pay December rent late. No, I didn't understand that.
So, ma'am, how much have you paid?
Your Honor, I have paid according to the agreement, and I've paid early. On November 30th, instead of $500, I paid $750. On December 15th, instead of 500, I paid 750. The remaining balance on the arrearage alone is 700, after those payments, is $777. That is due for me to pay on December 28th. Well, by the 29th, I'll get paid on the 28th, so it'll be a day early.
Hold on, you said you paid $750 on November 30th and $750 on November 15th.
Yes.
December 15th.
Okay.
I'm sorry, December 15th.
December 15th. Well, this shows $500 was due November 30th, so you overpaid that, and then $1,000 was due on December 15th. And you paid $750 because you overpaid on the 30th, correct?
Yes.
Okay, and so you have until December 29th to pay $777, and the plaintiff is stating that you have to pay that plus
$1,122.
Okay, and so Mr. Landau, your response, please.
Yes, Your Honor, the conditional dismissal does indicate that by December 29, she must pay the remaining balance, which is $777, along with all charges due under the lease that accrue through that date. The goal with these conditional dismissals is to have the defendant catch up on her arrearage, and this is for all tenants, to catch up on their arrearages, not, under this extended payment plan, not to just catch up on what's owed as of the date of the court hearing, and then still have a lingering arrearage by the end of December that 3 days later is actually going to be 2 months worth of rental arrearage and have to start a brand new case on the rental arrearage in January on what's now going to be 2 months worth of rental arrearage. And that's what I negotiate on all my conditional dismissals. I make it very clear to tenants that they're also going to have to catch up on the December rent. The manner in which I trained Mr. Borkin when he joined our office is to do the same thing. Obviously, I'm not Mr. Borkin. I was not part of the proceeding on November 17 when this was negotiated out. But that is his routine practice. I know that's how he communicates with tenants, except that there can be some misunderstandings that occur. But that is what we insist upon. And if Ms. Waleed wasn't able to do that, Mr. Borkin would have just gone before Your Honor and sought the entry of a judgment, giving her 10 days in which to pay. So instead, we gave her a month and a half to catch up. But that would be including the December rent.
Okay, and so, Ms. Waleed, you have a master's in business, correct?
I do.
Okay, and so one would presume with the master's in business that you understand the language and the principles of making the payments with what would be due, and then how you would still be in arrearage if you were not paying December's rent also.
No, Your Honor. My master's degree is in business and is not in law. But I do know from my master's that the court order is the binding document. And I guess, Your Honor, I just did not understand, and it's not spelled out. Mr. Borkin and I did not discuss December rent at all. And when I looked at the document, when he told me the number of $2277, that was to catch me up with the arrearage. I understood that. I understand also that I have the lease that's ongoing because I wasn't moving out. And I do understand, and I have paid and I'm willing to pay the late fees up until we came to court. But I felt like,
ma'am, why should your landlord continue to accept payments 1 and 2 months behind?
because because it would be 1 month behind, Your Honor, because we entered into this negotiation. If the landlord, and because I have paid the late fees, and I have shown that I have a willingness to pay this landlord every 2 weeks until it is caught up. And what's at issue here with myself and Mr. Landau is that he says that he doesn't have authority, and he said that he called the owners of the apartment complex just now. He only has the authority to extend out my payments to catch up for 1 month. And I asked Mr. Landau to extend it out for 2 months with payments every 2 weeks, and they are not amenable to that. I feel that because
Ma'am. What is happening now is that now it's snowballing. And so that is why, as Mr. Landau just stated on the record, that the agreement is as it is because it allows you an opportunity to catch up on the arrearage and not get further behind. Because now you're talking about you are catching up on the arrearage, but you're still behind. And now you're wanting an additional 2 more months to catch up on what's going to be due for December and January. So the order was entered. If you'd like to get legal representation, and the court even asked if you understood everything that was going on, you stated yes. And Mr. Borkin had put all those terms on the record. You can certainly file a motion if you'd like.
I can certainly file a motion. I didn't hear the rest of it, Your Honor.
If you would like. But other than that, this conditional dismissal has been entered. And I believe it's been entered. I can't tell on this.
It's entered, Your Honor.
Screen.
It was entered November 28th.
Because, ma'am, at the end of the day, I don't believe that the attorney that was here that day would have agreed to anything else. I mean, maybe he would have, I don't know. But since this would have been on November 17th, before November 17th, I believe it was. And I would have, if I would have entered a judgment, ma'am, then you would have had until November 27th to pay your move out. So I'm not, you might want to contact some rental assistance place, ma'am, or some low-cost attorney as well, and see what your options are. But at this point, I don't have a basis to set this aside.
And you don't have the basis because you say that I understood what Mr. Borkin put in the conditional order?
Yeah, it was all put on the record.
Mm-hmm. Well, I didn't understand that, Your Honor. Just as I didn't understand, and I asked in your courtroom what signing one of the check boxes for A, B, C, or something like that meant that they would be able to evict me without even coming back to court. I did not understand that either, and asked for that explanation while we were in the courtroom.
Right, and I gave that explanation. That means that they would submit an accounting along with an affidavit of noncompliance and an order of eviction all at the same time if payment was not made timely on any of those dates. Mr. Landau, we can do one of two things.
Okay.
One of two things. We can set this for January 3rd, and then we can just hold it as a hearing and enter a judgment accordingly if there's a resolution, or we can hold the hearing. That's up to you.
So I didn't understand that, Your Honor. We can hold a motion on the 3rd, or we can hold a hearing on the 3rd?
No, I'm sorry, I directed that to Mr. Landau right now. Just one moment. Mr. Landau?
Oh, yes, Your Honor. When you said just one moment, I thought you were addressing something else. So the options are to hold a hearing on January 3 on, let's call.
On your complaint that you filed for, for possession.
I'm just looking for the court to uphold the conditional dismissal that was agreed to on November 17th.
Well, and again, ma'am, you sent a correspondence in, I believe you sent it via email maybe to my landlord-tenant clerk. This was not a properly filed motion. The court has not heard anything that would be a legal basis to set this consent order for conditional dismissal aside. And so the court's going to proceed accordingly. And so, ma'am, you have until December 29th on your remaining balance there.
All right, Your Honor.
Have a good day. All right, thank you, Mr. Leo.
Thank you, Judge. Have a good day.